This is Beyond a Reasonable Doubt with your hosts, Mark Garrigus and Gary Smith.
Gary, you having a morning?
I've had a few computer problems and, a fight with the neighbor dog. It's been a morning. But first of all, Mark, I'd like to thank you for adjusting our recording schedule a little bit. Happy Father's Day to you as everyone listens, to you and the whole audience. And as we record, happy birthday to Shane from our team. It's his birthday, and I just want to make sure that we send him a little love.
Wow. It's happy birthday as well. That's quite an intro.
Yeah.
Quite an intro.
Yes.
So we have quite a bit. We got quite some range today, don't we? I mean, the U.S. Supreme Court came in with a couple of interesting decisions. The 6-3 decision saying that the Trump era ban on bump stocks was unconstitutional, and basically a ruling that, if you believe the majority, is based on the textual analysis of single function for a weapon. If you take a look at the dissent, which I believe was written by Sotomayor, she actually goes through and stacks quotes from the 6 majority justices talking about leaving these kinds of interpretations to congressional intent. And then one little fun fact, when she does that string cite of quotes, she does it by seniority of the justices, which I thought, well, that's somebody who knows who that was not randomly done.
No.
It was definitely the odds on doing the string cite with the 6 and the quotes on statutory canons of construction is enough, but then to do it and organize it by seniority, some next level analysis.
Yeah, I think a few clerks might have spent some time working on that. It was a clever way to do it. I agree. Also, they came in with a 9-0 ruling to on the birth control, the pill, right? Nevaprestone. Maybe I'm mispronouncing that. For everybody who's been arguing about the fracture, as I just discussed, on a 6-3 and sometimes 5-4 when the chief rolls to the left. The 9-0 decision is interesting. It's an interesting read as well. For I think that portends that they understand that you can't go much farther than they already have. Yes, and thankfully so, because it's certainly a welcome ruling, especially a 9-0. I think that sends a bit of a message, especially as we lead into an election cycle where this is going to be a large issue.
Yeah, and the standing issue is interesting. There's just a lot going on at the courts. We could do a whole episode to that. Maybe we will. I wanted to move because it seems to, I don't know if it's entered your world, but certainly mine, not the least of which is because the defense lawyer is somebody I know, and he's married to a Kasabian, Alan Jackson, and Alan is back in Massachusetts trying the Karen Reed case. You've been following that, Gary?
I have been following it mostly because you've been commenting on it, and it's one that I think has gone in and out of my world. I certainly remember when it first came to issue, and it's sort of waxed and waned over the months in between, but it's now coming back into my world, and not the least of which is because there's a few cops who have been forced to testify, and to say it's been spicy would be leaving it mildly.
So often, it's hard to know what's happening in a courtroom, given what I was getting reports, if you're not watching on TV, to know what jurors are. But this has been televised, so I thought we'd play a couple of snippets if you have. And I think one of them, I don't know if you have it, Gary, do you have the cross-examination by Alan Jackson, who is one of Karen's co-counsel defense lawyers, I believe his name is Detective Proctor, about some texts that he was sending about Karen Reed.
Correct. This is Trooper Proctor. And to give a little background on people who may not be following this the way we are, this is a case where a woman was dating a police officer. They went to a few bars. She dropped him off at a house, depending on whose version you believe. He was then found several hours later in the snow. He passed away, unfortunately, and she has been charged in the subsequent days with murder. It's the allegation being that she hit him with her car and then left him for dead. And
backed up into him. Correct.
She dropped him off, then backed up into him. He fell in the snow. She drove away, and then he died. And she is now on trial for his murder. This is Trooper Proctor, Michael Proctor, who is the lead investigator for the Massachusetts State Troopers.
During the course of your investigation, your figures of speech include the following. She's a bitch.
Objection.
Is that right?
Yes.
A whack job, correct?
Yes.
A retard, right?
Yes.
Her balloon knot leaks, right?
Yes.
No ass, correct?
Yes.
She's fucked, according to you, right?
Yes.
Ass leaker. That was the word you used, a figure of speech, right?
Correct.
A girl who shits herself, right?
Correct.
And then fuck her, correct?
Correct.
Would you agree, Trooper Proctor, that you have dehumanized Karen Reed during the course of your investigation with comments and words like this?
Objection.
I'll give you this one, Mr. Jackson.
Would you agree with that?
I would say based off that language, yes.
And you admitted, in your own words, that the cop homeowner wasn't going to, quote, catch any shit, right?
Correct.
Because you were out to quote, make this cut and dry. Isn't that right?
The homeowner wasn't going to catch any shit because Mr. Elba had nothing to do with Mr. O'Keefe's death.
Because you were going to make sure that the case was cut and dry. Those were your words, right?
Objection.
Sustained.
And Trooper Proctor, it would be far easier for you to pin it on the girl who's just a whack job cunt, in your words, who you hope just kills herself, right?
Objection.
Sustained.
Shame on you, sir.
Objection.
All right.
Even the judge gave him the one. Most judges, I would say 99 times out of 100, when she said, I'll give you the one, Mr. Jackson, most judges would have sustained the objection and admonished the lawyer. I don't think that this judge was real happy with Trooper Proctor and the texts because obviously the theme here is that the cops kind of rallied around the two cops who actually beat up and presumably killed or caused the death of the person that Karen Reed is being charged with running over.
Yeah, it's been reported that a lot of this jury is predominantly female, and apparently they were pretty horrified by the reveal of these texts. It's going to take everything in me to not name this episode "Leaky Balloon Knot." That's wild.
I missed this because I'm not watching. Did she defecate or something? Is that what provoked all this during the interrogation or while in custody?
I've not been following it closely enough to know for sure. One would certainly assume that based on the numerous times that he alluded to that in his text that Mr. Jackson highlighted there. Wow, that's quite a cross-examination.
Yeah, it's hard to believe, by the way. Maybe they did, and I'm just under the weeds. Normally, what the trial practice is, you have something like that, prosecution moves to exclude it. They say it's more prejudicial than probative. Clearly, in this case, it is probative because you've got a lead investigator. You've got arguably that he's trying to frame the accused, and he's trying to frame the accused. You've got the added bonus if you were the defense that not only trying to frame the accused, but as was just highlighted in that cross, at the same time trying to make it so that insulate, if you will, the cop homeowner, and you've got this the proverbial circling of the wagons, and that the investigation should and always should be susceptible to a thorough cross-examination, investigation by the defense, and holding them to account. I mean, that is the whole idea. The system is premised on that, because if you don't do that, then you have the possibility, as we've seen many times in recent history, of somebody getting framed or caught up in a bogus investigation.
Yeah. How long do you think there is left in this trial? I mean, when do we expect to see a result?
I've been talking I should say talking. I've had a call recently with Alan, and I didn't ask him that because it was on a wholly different matter, but I will circle back with that. I believe that the prosecution's case in chief, they're nearing resting in this, and then people are speculating as to whether she takes a stand. And based on everything I've seen, I can't imagine why they would put her on the stand.
Yeah, I agree. All right. So there's another case that we've been following. We've covered on this podcast, in the months past, but has since come back to the forefront down in Atlanta. And there's just been some absolutely wild developments this week. And that is the YSL RICO case, which involves a rapper that many people are familiar with named Young Thug. Let's just play the first clip here, which is a little long, so bear with us, but I think that it is very, very important. So let's check it out, and you can pause as you see fit and comment.
Note that for purposes of record. While I'm going forward, what I was told was that Mr. Copeland said, and you haven't answered my question yet. I'm not going to answer that question. You're not? No, I will not answer that question. Why will you not answer that question? Because I want to make sure that what I say is accurate, and I'm not trying to. No. I'm asking you, how did you get this information? I'm not telling the court.
I'm going to pause here. I'm realizing that this leaves out.
Let's set it up.
Yeah, it leaves out a little context. My mistake.
Yeah, no, it's not a mistake at all. The judge is asking for the defense lawyer. I believe his name is Brian Steele. I don't know. Correct. Brian. He's apparently very good friends, at least reportedly, with Scott Grubman, who was a guest of ours who had represented Kenneth Cheesebro, who was one of the defendants who was indicted in the RICO action with Trump. That Brian, who represents the Young Thug, has bringing to the court's attention that he has found out that there has been an ex parte in camera proceeding with the witness who was sworn and on the stand with the prosecution that he was not told about. So understand that. There's a witness who's been sworn. I believe his name is Kenneth Copeland.
I think that's right. I'm not positive, but I think that's right. And yes, he was sworn in a few days before the clip that you are seeing, and he had refused to testify. And then there was a meeting with the judge, the prosecution, the witness, and his lawyer that the defense was excluded from. And that after
not told about.
Correct.
And that's the key.
Yes.
Not only was excluded because you can do things that are called pitches motions, where the prosecution or the sheriff's representative will go into the judge's chambers and they'll talk about personnel records and things like that. But the defense is notified, and that's usually in response to a defense motion. Here, we're talking about a witness who was sworn, who's been refusing to testify. Now, apparently, they're in judge's chambers. This witness, fast forward, we've been watching, he is now testifying. In between all of this, he's meeting secretly with the judge and the prosecutor in chambers. Somehow, I have my theories, but somehow Mr. Steele, Brian Steele, finds out about it. And he's confronting the judge. The judge doesn't want to talk about it. All he wants to know is, I want you to snitch on who told you.
Well, let's go even further. The judge doesn't want to talk about it, but the judge also doesn't deny it. The judge has never goes so far as to even remotely deny it. He just goes straight to, how did you find out about this? And if you did find out about this and you won't tell me how, then you're going to be held in contempt. And you'll see a little bit more of this as we go forward. And I appreciate you setting that up, because I've been too in the weeds on this case, and I forget that I know things that might not necessarily be in the clip. But let's watch, because it's a contentious exchange that leads to a surprising outcome.
Not answer that question. Because I want to make sure that what I say is accurate, and I'm not trying to. No. I'm asking you, how did you get this information? I'm not telling the court. What I'm saying is based on information. Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems. We can have this. I have problems right now. Okay, I know. Look, I don't want to know about your problems. Okay, at this point in time, all I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that somehow you have surreptitiously gotten information in regards to the court's private ex parte.
I'm going to pause here.
Well, by the way,
does this drive you nuts? Sorry, go ahead.
Yes, it drives me crazy.
It would drive me crazy as a Luddite here.
He's telling Steele, I don't care about your problems. Excuse me, my problem is I'm sitting here defending somebody who's accused of a potentially life case. You're having secret meetings with the witness who's on the stand, and you're telling me that you want me to tell you how I heard about this? That's where we're shifting this to. And by the way, we'll have the record so an appellate court, ironically, is going to know.
That's the part that drives me nuts. You're sitting here right now in the middle of this case, and your answer is like, well, after we convict him, then you'll be able to address this. How dare you? Like, we're sitting here right now. You're the judge. What do you mean? You're kicking the can down the road right here in the middle of this?
But also you've hit your fingers on the pulse of the irony here. The irony is, fast forward, we'll talk about what happens next. And an appellate court did come in, but a lot sooner than this judge thought.
We'll get there in a minute. Yes, that's absolutely. It's just wild here. Let's keep going.
Conversation with a party. I mean, a witness who was sworn in Friday. The court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland. Tell me how you got the information. Listen, whatever you want to do. Tell me how you got the information. Then we can go ahead and go forward. I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court. It concerns me that you have proprietary information. Why is it information that
proprietary information? Who are you, Apple? You're someone leaked the new iPhone? Get the hell out of here.
Trade secrets case. You've got proprietary information. You mean that you're the judge? You've got your thumb on the scale of this trial, and you're upset that somebody narked you out?
You're meeting with a witness, and we'll get to it in a second, but allegedly intimidating them or having someone else in chambers intimidating
them. He's not meeting with him to wish him well and give him a fruit basket.
Proprietary information. Yeah, someone leaked the iPhone 16 and you've put the specs online. Get out of here.
That you should not be having that was ex parte. Why? With a party. Why? State of Georgia. How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court. Okay. Or excuse me, let me rephrase that.
I like that. He calls it an honorable court, and then he goes, excuse me, let me revise that. This court.
Court supposedly said I can hold.
So ridiculous. By the way, this judge fast forward finds him in contempt and sentences.
Oh yeah, we'll get there. I think that it's worth watching. Let's finish the clip out. I'll stop interrupting.
Told you until the end of this trial. Ms. Hilton supposedly said actually all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did. Mr. Steele, I still want to know, how did you come upon this information? Who told you? What I want to know is, why wasn't I there? Why, sir, I'm going to hold you in contempt if you don't tell me who tell me who this information was. I don't want to be held in contempt. Well, then, not answering that question. That's attorney-client privilege information. I am not attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out. I tell you what, I'm going to give you 5 minutes. If you don't tell me, if you don't tell me who it is, I'm going to put you. I'm going to put you in contempt because that is not attorney-client privilege. Attorney work product privilege. I am not. How did you get that information supposedly from my chambers? Did somebody tell you? I'm not. You should have told me. You got 5 minutes. Well, I don't need it. I want to continue. You got 5 minutes. This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No. I'm doing that at this point in time. So you'll have a choice to make. All right. Take Mr. Steele into custody, please.
So now we fast forwarded past the 5-minute recess, and Mr. Steele is being taken into custody. Young Thug's lawyer, as Young Thug sits there.
By the way, this judge should be. They should remove him, declare a mistrial. What he has done here is so over the top, outrageous. It's hard to even believe how insane here.
It's wild.
Okay.
And you're going to see him in a moment here as he's taking off, articles of clothing as he prepares to be taken into custody and going into jail. You're going to see him ask again for a mistrial, and the judge is going to deny it. And it's a bunch.
Yes, sir. You certainly
Brian, good for Mr. Steele.
Yes, I agree.
Mr. Williams is not
Good for Mr. Steele. By the way, I never would have been this calm.
Against his will, my will, you're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you denied, but I'd like you to deny our motions for mistrial. You denied the other people. I've denied your motion, but I'll certainly take that under advisement, sir.
Yeah. How's he taking it under advisement?
Yeah.
You realize what's happening here. He's taking out the lead lawyer in the middle of a trial for summary.
We're going to be in recess for the next 5 minutes.
By the way, this judge has, under any interpretation of contempt, he doesn't have the right to, because he's a witness, to summarily sentence somebody for contempt on the basis of something that didn't happen in his presence. I mean, the whole thing is just such a absolutely legal abortion. I can't even understand how we got there. And this judge, also, do we have the clip where Ashley Merchant now is involved?
Oh, yeah.
Okay.
Are you kidding me? This is so fun to me. I have every clip you could possibly want, Mark. This is just absolutely absurd.
In this case, I just want to know who told him this. That's all. I'm not asking him to release or otherwise tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merchant, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that.
That is so that you understand. By the way, Ashley Merchant, some of you may remember, Ashley Merchant is the same lawyer who represents one of the co-defendants in the Trump case who exposed the Fonnie Willis, Nathan Wade debacle.
Correct.
And by the way, is right now schooling this judge. I don't know. And by the way, this is also a case that is brought, if I'm not mistaken, by Fonnie Willis's DA's office, who participated in this ex parte communication with the judge and a witness, and basically, if you believe at what's been reported, coerced or got this guy to flip in the middle of saying that he was going to take the fifth, and excluded the defense as well. What a cesspool, prosecutorial cesspool this county is.
Yeah, I mean, Fonnie Willis is just, the fact that she was just reelected is absolutely insane to me. It's
get what you deserve. You want that as your DA. And by the way, this judge, the fact he's still sitting on the bench is mind-boggling to me. I mean, there's courts of appeal around that would summarily remove him from a case for pulling stunts like this.
I'm frankly surprised they haven't done it already. And Ashley Merchant is just schooling this guy as she is just a rock star. It would appear from anyone who's been listening to this podcast for a long time. Let's watch her keep doing it, because it's very fun to watch.
For him to answer your question does not mean that you have the power to hold him in
So
contempt.
you can come into court, Mr. Merchant, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there, because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You are a witness to that, because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you weren't part of them, by nature.
Okay. Well,
you have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also.
But you got the information. But here's the thing: you got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay, I said that one of the things is it's either one of two ways. He either eavesdropped, which I don't believe he did at all. I don't believe that for a minute. But I do believe that somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned it.
I think that he caused that particular circumstance. I think that he had a conversation.
He caused that particular circumstance. You didn't include him in a conversation. He learned about it some other way, and that's his fault. Wow.
Welcome to the world of criminal defense. And people say, how do you sleep at night when you defend these people? And I always say, I know that the what if my client is innocent? That's what gives me pause. But this is a pretty good example of exactly why, if you don't have a zealous defender, why things go awry in a system. If you don't have people who are willing to stand up and hold the government accountable, government meaning the prosecution, government meaning the court, this is what you have. And by the way, if this wasn't televised, people wouldn't even know it. They wouldn't even believe it. They think we were spinning this.
Yeah, they would. And shout out to Mr. Steele, by the way. When he was sentenced, ultimately an appeals court stepped in and stayed the ruling. He was sentenced to 10 weekends in jail, 20 days. And he stepped up and said, fine, if that's your ruling and if that's what I have to do, I would like to serve in the same jail as my client so that I can continue working on his case. And I just think that is a baller move. Like, that's awesome. Like, by all means, like, yeah, this is ridiculous. But if that's what you're going to do.
For all of those who say, oh, criminal defense lawyer, blah, blah, blah. If you're accused of a crime, that's the kind of lawyer you want.
Exactly. I would hire this guy in a second, and I would also move out of Fannie Willis's jurisdiction if I was living there. I mean, God, can you imagine being accused of a crime in this jurisdiction? This is just absolutely insane.
Yeah, it's beyond belief. We've run out of time, unfortunately. I promised you that I'd get you out of here 10 minutes before now, Gary. But
I appreciate that, Mark.
I could talk about this forever. To everybody who's watching this, happy Father's Day.
Yes, happy Father's Day.
Enjoy the day. Enjoy the one time that old routine. We should have played a clip of it. Of Daddy gets the big piece of chicken. It's one of my favorite routines.
Yeah. Yeah, that's the one day a year where that's true. Mark, you enjoy your Father's Day as well. And I would presume your grandfather's day, you're going to get to enjoy the little one, I would hope. And I can't wait to see you again in person in the coming days.
Thanks, Gary. Talk to you.
All right. Bye-bye.
Thanks for listening to Reasonable Doubt. Subscribe on YouTube at youtube.com/Reasonable Doubt Podcast.